back to our discussion on the share subscription and share purchase agreement that we've been going through over the last 1 week. This week we'll probably close this out. We've completed our discussion on conditions precedent, and we were at the stage that the conditions precedent have been satisfied and a confirmation has been provided to the investor. Now, what happens during closing? All the conditions that have to be met for the transfer and issue of shares as well as the transfer of money, all of these conditions have been met, have been fulfilled. Now, if the investor is satisfied that all of these conditions have been fulfilled, then this agreement says that parties shall consummate the transactions contemplated in clause 5.3, we'll come to clause 5.3 in a bit, within 10 business days from receipt of the conditions precedent confirmation date, right? All transactions contemplated by this agreement to be consummated shall be deemed to occur simultaneously, and no transaction shall be deemed to be consummated unless all transactions are consummated. What this effectively means is that all of the steps below, which count towards closing, all of those steps will have deemed to happen at the same time, and unless all of these steps have happened, none of these steps would have been considered to have happened. So either we consider all of these steps that have been completed, that will be completed, or we consider the closing to have not happened, right? All right. At the Series A closing, what shall happen? 1, the investor shall pay the subscription amount and the sale amount to the respective designated bank accounts. Now, respective designated bank accounts will be defined as the bank accounts of the promoters as well as of the company, as the case may be. The company shall deliver to the investor duly stamped share transfer forms executed by the promoters in respect of the sale shares. Now that the company has delivered the share transfer forms in respect of the sale shares, the investor has a right to receive these shares, right? The board shall hold a meeting and pass appropriate resolutions for allotting the securities to the investor, appointing the investor directors. Now, obviously, as is the case in common parlance, this investor would have asked for one or more board seats, which shall be appointed at this closing meeting itself. Identify key personnel or directors, a copy of which shall be shared with the Series A investor upon closing. Convening an extraordinary general meeting immediately after this board meeting to approve the amendments to the AOA and MOA if necessary, and to confirm the appointment of the Series A investor director. Approving in principle and subject to the endorsements on the form FCTR, the transfer and sale of the sale shares from the promoters to the Series A investor. All right, so let's just quickly go back and figure out what it is that the board is doing. First, it is allotting the securities to the investor, the issued securities. Second, it is appointing directors on behalf of the investor. Third, it is appointing identified key personnel. Fourth, it is announcing an extraordinary general meeting. Fifth, it is approving the sale of the sale shares from the promoters to the investor. What shall the company do to prove that all of these steps have taken place? The company shall deliver the extracts of the resolutions referred to above. And 2, it shall also deliver duly stamped share certificates in relation to the Series A securities or the fresh issue of shares. Further, the Series A investor shall be entered into the records of the company as a registered owner of the Series A securities. The investor director shall be entered in the records of the company as part of the directors of the company. The company shall deliver a copy of the register of members and the register of directors as on the date of allotment and at the date immediately prior to such allotment, right? So effectively, I'm also delivering proof of ownership of those shares, including the resolutions as well as the copy of the member register as well as the copy of the register of directors, right? So at this point of time, I now have share certificates, I now have resolutions, I also have a copy of the register of members. What that means is now the investor has enough um, evidence to show that she or he is actually a shareholder in the company. We've mentioned that there would have been an extraordinary general meeting. What do I need this general meeting for? One, to obtain a consent from the shareholders by way of appropriate resolutions to amend the articles and memorandum of association. Second, the appointment of the Series A investor director. Now we know that this investor might have asked for special rights, which will be given to which are usually given to investors in such cases. These rights must be reflected in the articles of association. Furthermore, we've seen that you might have certain occasions where you might have to increase the authorized share capital of a company. Now, the authorized share capital of a company is mentioned in the memorandum of association, which means that the MOA may also have to be amended. So, who can amend the AOA and the MOA? The shareholders. They are doing so through this extraordinary general meeting. The director, the investor director, cannot be appointed by the board of directors directly. It has to be appointed. There must be a formal consent of the shareholders using a simple resolution to formally appoint the director on the board, which means that they will need to pass a resolution confirming the appointment of the investor director, right? Further, the company shall deliver the Series A investor extracts of the resolutions referred to above as a certified true copy, right? Okay. Promoters will have to submit a duly executed form FCTRS. Now, the form FCTRS, as we've discussed earlier, is a form that intimates to the RBI that we are selling our shares to a foreign entity. In this case, there is a foreign entity, and this duly executed form FCTRS must be submitted to the authorized dealer bank no later than 5 business days from the date of receipt of the sale amount, right? Finally, the company shall deliver to the investor a certified copy of the register of members as on the date of taken on record of the transfer and sale of the sale shares, and the date immediately prior to such transfer, similar to what we've seen in the issuance of shares. So effectively, a copy of the register of members to be delivered to the investor, showing that the investor is now the owner of both the freshly issued shares as well as the sale shares. Now, what happens post-closing? A number of regulatory requirements then kick in. The moment I've issued fresh shares, I must then intimate to the registrar of companies. The moment I have appointed a new director, I must intimate the same to the registrar of companies. So all of these things must take place immediately after or within 30 days of the closing date, right? The company will file within the period specified under whatever applicable law with the RBI in accordance with the foreign exchange management rules, right? So intimation to the ROC, intimation to RBI, and this is something that we've seen quite often nowadays: a directors and officers liabilities insurance, right? So this is something that has been coming up over the last few years, over the last few decades, that people are beginning to insure their directors and officers against liabilities that the company has taken on, right? And of course, within a period of 3 months of the closing date, the company will appoint one of the big 5 firms as the statutory auditor of the company, right? That is what will happen at closing and post-closing. In the next video, we'll go on to some boilerplate clauses, including reps, warranties, and covenants.